is perfect. I'll start exactly at 1 then. Thank you.
Wonderful. Thank you, Yusuf.
Thank you, everyone. Just once again, reminder for those that have just joined us, this session is being recorded and will be distributed among many platforms. If we can all be respectful and deal with the information that's been provided to us by the judiciary. At this stage, I just want to say that the judiciary has not yet finalized its version of what the new possible practice directive is going to encompass. We as the GAA are merely providing the information which is crucial to all practitioners in planning for trials that are going to be moving ahead, both in 2025 as well as 2026 and furthermore. Obviously, once the actual practice directive comes about, we will then be able to assess it. There'll be an opportunity for all legal practitioners to comment thereon. And likewise, the GAA will possibly be holding another session with all the members from all the different associations to discuss the practice directive, provide input to the judiciary, and in all probability, with or without our participation, the judiciary is indeed going to roll out their practice directive. Thank you for everyone for joining. This workshop will be distributed on YouTube as well, I'm told. So let's all be mindful. Thank you. As we all know, the Gauteng Attorneys Association, which is our provincial umbrella body, it's all our local attorneys associations, being the Johannesburg Attorneys Association, Pretoria Attorneys Association, West Rand Legal Practitioners Association, Soweto Legal Fraternity. They were all invited to participate in the joint judicial subcommittee meeting, hence our feedback session today. The meeting took place this Monday on the 10th of February 2025, was led by the Honourable Judge President Mlambo himself, Deputy Judge President Sutherland, Deputy Judge President Ledwaba, and Judge Davies. The Solicitor General's Office, as well as a large contingent from the Road Accident Fund, including its CEO, Mr. Colin Litswalo, was also in attendance. In addition to the usual attendees, a number of different associations were also called upon to attend. They are the Johannesburg Society of Advocates, the University of Pretoria Faculty of Law, the RAF, as I indicated, the judiciary was obviously represented, the Pretoria Attorneys Association, Johannesburg Attorneys Association, West Rand Legal Practitioners Association, as well as PIPLA, Babasa, members of various bodies of the Advocates Association. We had the Solicitor General, which I've indicated, and we had ADR Technology Group as well. Samla was there, as well as Nadal, together with the Black Lawyers Association. So as many members of the profession, they were all invited to participate in this information session, as well as the subcommittee session. So we as a provincial association, we obviously undertook to provide feedback from our previous information session in a bid to keep members of the legal profession obviously updated with developments. In a bid to cut out too much of the information, it was a 2-hour session. The short version is that the judiciary will distribute a practice directive very, very shortly. And we're just here to provide a brief summary, obviously still subject to verification from the judiciary of what that practice directive may contain, but in a bid to warn all legal practitioners as to what's forthcoming. Now, we're going to turn to what was the objective of this particular meeting. As we all know, it's the introduction of mediation into our current practice directives. How this will be affecting trials is of crucial importance. We must also bear in mind that with mediation, there's a accompanying cost aspect that will come for all legal practitioners, and obviously the utilization of Rule 41. So those are the important aspects that we'll be covering as far as today's session is concerned. Going to start with DJP Sutherland's address to all of us, which can be summarized briefly as follows: that the objective which the Gauteng division sought to achieve is basically compulsory mediation. And the effective purpose of the High Court was to afford public and legal practitioners effective litigation services. He indicated there are many ways in which an effective litigation model can be established, and in one of the ways that this can be achieved, given the current problems that we face, in his opinion, is mediation. He started off telling everyone about the current problems with the system, which we all know. He believes that waiting for trial dates all the way up to 2030 can definitely be regarded as unconstitutional, and that the registrar, in her infinite wisdom, in granting those particular dates all the way to 2030, these fictitious dates, in his opinion, is actually a palpable fantasy. In order to fix the system, he's suggested to us a radical consideration to the approach needed to be had by the judiciary itself. And although he's given the profession an opportunity to be consulted, he's not allowing any negotiations with the profession regarding what the effective model which will be implemented. According to him, this is solely for the judiciary to exercise its discretion, and this is the role of the judges itself. He says he understands what they're about to roll out is about to be endorsed and will be painful at first, but like everything else, as the introduction of court online and case lines, practitioners will get used to the system itself. He says, according to him, the ship on mediation has sailed, and it's now going to be considered as compulsory in order to achieve any particular trial date in this particular division. We're going to start off with cancellation of trial dates. So from January 2027, all trial dates are proposed at this stage will be cancelled. No one will have this particular date. During January 2027, we're going to be considering this as the utopian concept that they are outlining. The question that everyone has is what happens in the transitional period between 2025 and 2026. He regards this as the transitional period for the introduction and finalization of the mediation as a compulsory mechanism in order to obtain a trial date. So where any party is seeking to enroll a matter in future, you'll also have to proceed to confirm that mediation has indeed been attempted. This will be required to satisfy the registrar in the prescribed and acceptable manner in which they will advise us. And it will be crucial to obtain a mediator's report to confirm that the matter either could not be successfully mediated, and only on receipt of that certificate will any trial dates in this particular division, both South Gauteng and North Gauteng, will be allocated a trial date. So this has far-reaching consequences for all practitioners and a real change to the system itself. As far as mediators concerned, mediators were required to be accredited and have to be accessible to legal practitioners. He indicated the court will be providing a gatekeeping role, that no one will obtain a new trial date unless it follows the proposed process that's going to be distributed to all of us. Not only should mediators be accredited, he says, but their fees and their financial implications should also be considered, where the aim of these mediators should be to provide affordable mediation. This transitional period between 2025 and 2026, respectively, the key question that would arise is whether, during this particular transition period, what will take place in respect of the road accident fund matters first. The bottom line is, for future matters, if there's no mediator's report, and you have a current date in the third and fourth term of 2025, the matter will not proceed. So I'm going to repeat that shortly again. As far as road accident fund matters, there will be no change to terms 1 and 2 of 2025. So all of us who have matters in the first two terms will continue as per the norm. The usual status quo will remain. However, for all of us who have trial dates in terms 3 and 4 onward, as indicated earlier, no matter will be heard unless the parties have attempted to mediate the matter, and a mediation certificate is provided by the respective or allocated mediator. It is envisaged that for 2026 onward, all RAF matters will possibly be removed from the roll. And that's a very scary and daunting aspect. However, this is still to be considered, and it will be finalized in the rollout when the judiciary makes their final decision. However, there may be a possibility that if mediation certificate is obtained, that trial dates will be provided through on a much quicker basis. That's the ultimate utopian attempt by the judiciary. What is the primary aim? To enable the judiciary to create space on the trial rolls. They envisage that they would like to re-enroll matters more rapidly and deal with matters more quickly, instead of having to wait for years before matters become heard. This is particularly in respect of Pretoria as well as Johannesburg, just to remind everyone. The long-term aim of mediation will not only cover road accident fund matters, but also family court matters. For those of us dealing with commercial matters as well, 2025 will also remain undisturbed, the entirety of 2025. However, it is suggested at this stage that from 2026 onwards, all matters will need to obtain a mediation certificate. This includes commercial matters as well. So the entire way in which we practice has now need to be really looked at from the legal practitioner side. In terms of 2026 dates, for those commercial matters that are still on the roll and non-RAF matters, they will still be regarded as provisional dates. It is anticipated, and I want to repeat that, it is only anticipated until we see the practice directive, that once these provisional dates are secured, it is suggested that a mediation certificate will have to be obtained approximately 60 days before the matter is heard. These are non-RAF matters. And a practice note will then have to be submitted in order to secure your date for any of these commercial matters for 2026 onwards. I would assume once a directive is published that the same would be applicable for those matters in the second and third term onwards. So in essence, anyone with trials, specifically road accident fund trials in term 3 and 4, we need to start the mediation process as a matter of urgency to try and get to a point, if the matter is settled, obviously it will be removed from the roll. And if it is not settled, we need the mediation certificate given in 60 days prior to the matter being heard. At this stage, I'm going to repeat as many times as we can on the GAA side. This is all subject to the practice directive still that needs to be distributed amongst everyone. 2026 onwards, non-RAF matters will be also dealt with as indicated. It's going to be mediation. Without that certificate, you will not secure your trial date. So in terms of the judiciary, they've advised us that there's no other viable or alternative solution to address the current problems facing the judiciary in terms of long waiting for a number of years before being allocated a trial date. They believe that this is totally intolerable. In terms of the funding of mediation, that becomes an interesting subject that we all can discuss. The judiciary have put their hands up and advised us in no particular uncertainty that this falls outside their scope. And depending on the model which is going to be ultimately adopted, the mediators and mediation organizations, they should attempt to resolve this issue regarding the cost of these financial implications of mediations, both the administration cost, which is suggested at about R1,000, as well as the cost of mediators as per the draft protocol that was distributed. For those who don't and who require the draft protocol, please let the GAA know. We can then send you the draft protocol document. Remember, it's in draft format. At this stage, the RAF, many mentions was mentioned about it. Will they be responsive in this particular attempt, or are we going to be looking at a case where they simply not going to respond as they currently do? I want to just tackle, before I continue with that mediation only refers to trial matters. It is very important for all of us to understand that any matters on default judgment, even against the Road Accident Fund, will not be affected by mediation. Those will continue as per normal. Once again, I put the qualification in. We'll wait for the ultimate practice directive to come through. It's very important for us to make sure that we align our practices from today, especially looking forward to term 3 and 4. In terms of the RAF's responsiveness, we yet to get complete buy-in, but if the practice directive is put into place, like all other litigants, they will have to follow the practice directive. All right. In terms of critical to shorten lead times, the solutions offered by the judges or the JP in this regard have not rendered the desired outcome of reducing any of the lead times. And as a consequence, we're facing this particular practice directive. Just want to note that after the meeting, we'll have due regard to comments for issues raised. And in a nutshell, we're begging all legal practitioners to actually have a look at the practice directive. You're going to have a very short time to make any substantial input thereon. Once it is distributed amongst members, there'll be a due date, and this particular practice directive is due for implementation by no later than the 14th of April 2025. So I'm going to stop there. I'm now going to defer to Conrad. He leads the Gauteng Attorneys Association together with the Pretoria Attorneys Association on road accident fund matters. I'm also going to ask, once Conrad has addressed us, to ask the Secretariat of the High Court Committee, Marianne, to address all of us. She heads the Secretariat both in Pretoria and Johannesburg, and she is the one that coordinates all the respective meetings and the High Court Committee itself. Conrad, do you have anything to add as to what I said before I proceed?
Yusuf, thank you so much. Members, thank you for the opportunity. Mr. Wadi, you have actually hit the nail on everything that was said. I just want to thank all the members that did provide us with commentary. We assure you the commentary was put forward to the judiciary together with the commentary that we have prepared from the GAA side. So just the ring of the commentary was basically the same, and everybody that is included in RAF litigation had most towards the payment of mediators, the mandate of RAF officials, how the RAF officials will be mandated in terms of settlements. The capacity was questioned of the RAF in order to handle such a mediation process. The loss of trial dates was a very big issue, and as Yusuf has indicated, we were unfortunately met with a stone wall where it was very clearly said to us that this is not a negotiation, this is a consult of something that is definitely going to happen. A further ring of all the commentary was non-adherence of the RAF even on court order. How will they adhere to mediation agreements? Now, the meeting, if I can just explain it that way, there was no indication from the judiciary whether or not they have taken our commentary lightly or hard, whether or not it will be implemented or not. Notes were made by the officials, by the judiciary, by the DJPs while we were busy providing our commentary. and it was just indicated that we take note of it, and we will continue with the practice directive. In terms of the default judgment, I concur with Yusuf. However, once again, it was met with a stone wall where only a note was provided after we indicated to the judiciary that the default judgments cannot and simply cannot be affected because Rule 41A only kicks in after notes of intention to defend from the defendant's side. Once again, only note was made in terms of that. So another ring was that there is a specified court in our courts providing that the plaintiff can proceed in compelling the RAF, and most of you that does this litigation knows of these courts and utilizes them effectively as well. And once again, note was only take of it. We have no idea what is going to be in the practice directive, but I agree with Mr. Wadi that that please attempt to start aligning your practices to this imminent practice directive, whatever it may entail. So thank you for that, and once again, thank you for everybody that was willing and able to provide them with our commentary, and we assure you that same was addressed and put over towards the judiciary. Thank you, Yusuf.
Thank you kindly for that. Marianne, before we allow everyone else, would you like to comment if there's anything we missed out or anything you'd like to convey to the practitioners?
Thank you, everyone. Yusuf and Conrad, thank you. I think you summed it up very clearly. Just to convey to all the members that the Solicitor General is also in favor of this entire mediation project. And then what was interesting is, and that you forgot to mention that a representative of the United Nations was also present. So it's quite clear that this entire mediation project is a project that is widely distributed, and then also the someone from the Gauteng Premier's office was also present. I think that for our members, and it is true that it was said that this ship has sailed. We are definitely going to go the mediation route. And then we in a consultative phase and not a comment phase. But I want to implore everyone that and we all received, I'm sure that we all received the discussion paper 168, Project 94, the Alternative Dispute Resolution and Mediation Act for South Africa, that we have to comment on before the 15th of April, 2025. So have a look at that. Although, we were informed that, this is going to happen, I still think we have a bite at the cherry by commenting on that that discussion paper 168. I don't know if everyone received it. We can forward that to everyone as well. Yes, I think that we as the GAA, we're your voice, and we want to comment on everything. Unfortunately, too much, but yes, we are there to act on your behalf. Thank you.
Thank you kindly, Marianne. Practitioners, we're now faced with a situation of changing the entire way that practice and litigation has unfolded before us. We've raised the fact that we're hoping that this is not just another hurdle that practitioners doing RAF work have to jump through to in order to obtain a trial date, which has the opposite effect of merely increasing legal cost. If I look at it, an experienced mediator is going to cost approximately 25,000 Rand for the mediation. This is just an approximate, plus the 1,000 Rand administration cost. At the outset, when this particular practice directive is going to be published, we suggest that we as a legal profession and mandated by yourselves negotiate directly with ADR or the appropriate mediation bodies to try and reduce the number of costs. We have noted to the judiciary, Conrad in particular has noted that smaller law firms may not be able to afford a mediator to try and get a mediation certificate. While that transpires, opportunity exists. There are pro bono hours required for all of us that's going to be implemented extremely soon. This is an opportunity, and we are going to be opening the doors of communications with the LPC, whether we can get our pro bono hours while sitting on some of these facilitative mediations. And that is one of the aspects that may come out of it. For those of us specializing or not specializing in mediation, since it's becoming compulsory, the GAA will also be advising you, just like the LSSA, of various different mediation training that we can all, as practitioners, go on to. If this becomes implemented, it's an opportunity for work for most of our legal practitioners, and it's an opportunity as well, even if you don't intend participating as a mediator, to go through the training to understand the mediation process. For those of you not involved in the mediation, and I'm sure just a few of you aren't, the facilitative mediator merely plays a role in bringing the parties together. He does not facilitate a decision, does not make a decision, and he just tries to bring the parties together to find a common resolution. If a resolution is found, it is anticipated that agreement should be drawn up. All practitioners must just take heed that incorporated into your normal cost order, as you would do in an order of court, part of the mediation settlement, a discussion in terms of legal costs should be a necessity, especially if it has been a successful one, dealing with whether the defendant would indeed pay the legal cost, including the cost of the mediator and possibly the administration fee, if that agreement did not allow for 50-50. In any event, once a settlement is reached, we anticipate moving through to the settlement court to make it an order of court. As we all know, that would be essential for us in order to execute upon any agreement reached with the defendant, whichever defendants they may be. At this stage, I just want to pause because there is a question from Nicole. How are parties forced into mediation process, which is voluntary in nature? Constitutional rights, access to court, section 34. The idea of mediation bill for commercial, civil, and community matters is still under consideration under the SALRC, discussion paper 168, that is correct. Project 94, the closing comments are only due on the 30th of April 2025. I would suggest that comments of any kind are duplicated and sent to SALRC. Nicole, I think that's a good idea. We're looking forward to that. We've dealt with voluntary mediation process. The Road Accident Fund, which I'll deal with in a few seconds, has made comments on what their attitude is going to be to the forum, and we'll still wait to see their formal comments, which will come out once the practice directive is actually established. We've dealt with this at length, whether it's voluntary or it's going to be forced upon us, and we'll see how their practice directive actually turns out. As we've indicated, the prima facie view of the judiciary is simply it's gatekeeping. You're not going to get a trial date, and if you stand the possibility of your matters being removed, you don't have a mediation certificate. How does the judiciary actually see this? They actually see it that if the defendants have an opportunity to be confronted with time and someone overlooking, in this case, the mediator, and has the time and comes through with effective attitude of trying to settle the matter, as Conrad has indicated, with a mandate, that's all that's required. Someone to give them an end time to look at the matter in order to make a decision. I've personally raised the fact that we hope that this doesn't just transpire into an expensive exercise where we complete the mediation and the rolls get clogged again. So it all depends on the participation of the defendant. However, that ship apparently, according to the judiciary, has indeed sailed. They see this as a true mediation attempt will result in majority of road accident fund matters and others being brought to a conclusion. That's the way they see it, and that's what they anticipate for us. At this stage, I don't think it's necessary to give you too much comments, just that the CEO of the Road Accident Fund had addressed everyone. His questions was, how was ADR Technology Group actually selected as a service provider? He then wanted to know what the protocol fees are going to be and what are the structures. Are they going to be fair? He also addressed whether the selection of the mediators would be transformative in nature, and who will they have protocol, will they have enough ethos to deal with these particular matters? And I don't think he understood what facilitative mediation is, but he raised certain good protocol questions, and his view was once it's published, he will be commenting thereon. So in terms of Rule 41A notice, I suggest everyone goes and look at the Rule 41A, adapt it to your necessary matters, and try to deal with it both for liability matters, quantum matters, or general damages matters, whichever it is, and start preparing your documents. Once this document from the judiciary is released, we'll all have an opportunity to comment. And if we require a further session with the mediation or people from the mediators to tell you who to contact, communicate with, we definitely can hold one with ADR and the other mediation groups that may be accredited depending on what the protocol or practice directive comes out. In that way, we'll try and facilitate easy communication so that when it's implemented, practitioners will have an easy access to these particular mediation groups in order to try and achieve their certificates. From our side, that's all we can provide from the information side. I want to ask everyone to be mindful when putting their comments through, not to be too much bashing on defendants, but you're welcome to open the floor and ask us a few questions. Where we can, we'll answer. At this stage, it's just an information session, and obviously all answers will only come out once the practice directive is released by the judiciary. Can I take questions? Nicolette, if I can ask you to check for hands, if possible, if there are any questions.
I will check, Yusuf. We are just waiting that people raise their hands in the event that there are questions.
Thank you. While we're waiting for people to ask questions, obviously the practice directive that's anticipated will probably be the first phase of us considering what the content thereof is, how it's going to affect our trials. I think I've given you a short summary of what is anticipated in there. Obviously, we can't guarantee what is told to us will be the eventual document that's provided through by the judiciary. It's going to be an unusual fees to try and get hold of mediators at first. We are assured by the various mediation groups that they have the facilities, they have the number of mediators to facilitate at minimum 200 to 300 mediations per week. If any of your mediators still want to be part of the project, I suggest you contact ADR or communicate with us, and we'll definitely hold one more further session where we're going to introduce the mediators that are available to everyone so that it's easy access for all our members. In absence of any comments either on the group, alternatively by raising your hands, I suggest that the meeting can then be brought to a conclusion. And I'm sorry to shock everyone, but we've been faced with the same information as you have at the same time. Thank you for joining us at the GAA.
Apologies, Yusuf.
Please go ahead.
There's a question from Hagerman and Associates that reads, what effect will mediation have to pre-trial applications at High Court?
Thank you for that. Marianne, you want to try and attempt to communicate that, and then Conrad, I will have your answers, and then I'll go thereafter.
Just say that again. I'm sorry that just to the question.
Marianne, the question on the group chat is, what effect will mediation have to pre-trial applications at High Court?
I will answer if
Thank
Maria.
you.
Well, there being a pre-trial application, if I understand you correctly, then there is no pre-trial and you want to try and force them to have a pre-trial. If I understand you correctly, that will of course affect it, because now from all the trial dates from 2027 and onwards is going to be automatically removed, well, proposed to be automatically removed. So that means that possibly you haven't had a trial date even allocated to you. So that will mean that mediation will affect in terms of you having to provide a mediation certificate before applying for a trial date if you don't yet have one.
Thank you, Conrad. There's a further comment. Marisa, just to confirm, the recording of the session will be sent through on the group. Maria, Nicolette.
Yes, if we can send it through on the group. The challenge we have with that is it is usually a very large file. So it's too big for people to download directly from a WhatsApp group, because WhatsApps do not carry that amount of data. And that is why we will be creating a YouTube channel for the GAA where people can download it. But we will download the link to the YouTube channel within the next day or so.
Thank you for that. A few more questions. Can a general mediator certificate be used? Or one will have to specialize in that area of law currently studying general mediation. So everything's going to go through ADR, but obviously we'll wait subject to the practice directive being issued as to the selection of the mediators. ADR did a presentation to the subcommittee in terms of their volumes that they may be able to administer. So the idea is, in theory, that we'll go through them. They will select, give parties a list of mediators available on the platform. The parties, in terms of Rule 41, will basically have an opportunity to select 3 mediators. If the parties can agree to one, they'll then proceed with that particular mediator. And that selected mediator between the parties will provide the certificate. And we assume the practice directive in that will have a form to be completed like we usually do on case lines that will attach it, will have to be completed together with that form. And once it's uploaded, you can then follow up with the registrar to either retain your trial date or alternatively apply for your new trial date. That's the way I understand it. There's ACE. Do I understand correctly that mediation is at this stage only applicable to trials and not default judgment trials? That is absolutely. Conrad, do you want to agree with that?
Yeah, and I will answer Mr. Trita and Tim Vlok's questions as well, Yusuf, just to give you a little bit of a brief shame. Well, our opinion is that it doesn't affect the default judgment trials, and that opinion was clearly conveyed to the judiciary. Once again, as I say, only note was made of it. So unfortunately, we don't know. We are of the opinion that yes, but this is only at this stage. We will need to see what the directive says about that. Mr. Trita, can the judiciary enforce the said directive compelling parties to mediate without contravening the intention of Rule 41A to D? Well, Mr. Trita, I don't think at this stage the notion was in terms of that. The notion was towards a constitutional court judgment, which we will share as well, where they indicated that in their belief they will be able to do that. So we will have to wait for the directive to see what contravention there is and if there is any. So once again, we are only preemptively holding this meeting to warn practitioners, but we do not know whether or not the practice directive will indeed do that. So we will need to assess once same is received. And then Tim Flock, has any draft process being outlined in the event that the defendants refuse or fail to hold a mediation in terms of either keeping your trial date for the third, fourth terms of 2025 and onwards, or obtaining a trial date? Mr. Flock, as we have indicated, we have also provided that information and comment to the judiciary. Once again, only note was made of it. I unequivocally explained to the judiciary that the courts currently exist of the compelling discovery and compelling for decisions in terms of Regulation 3 and compelling pretrials and so on and so forward, was basically put there because of just a basic, well, we can either call it and somebody ignoring you from the RAF, or just them not coming back to you at all. I was assured that a note is made of it, and I requested that at the very least the practice directive has to provide a recourse for the plaintiff, in that if a no Form 27 is delivered to the plaintiff, that they at least have a recourse in following, and the practice directive should clearly and concisely set out, and the words that I used was, where does the buck stop at the plaintiff? What does the plaintiff have to do in order to assure that if there is non-adherence of the court rules, what does the plaintiff have to do until the judiciary will be happy with them applying for a trial date without a mediation certificate? So that comment has definitely been made, and we were assured that note is taken of that.
Thank you, Conrad. Marianne?
Just to reiterate, Judge Davies was of opinion, and I think that is what is going to be in the practice directive, that you are going to be forced to attempt to proceed with mediation. So Judge Davies, his opinion was, as well as Judge Ledwaba, is that you have to then bring an application to compel the opponent to answer to your Rule 41A notice. So that will be, you will be compelled to do that. But if a mediation, if the opponent or the party does not pitch at the mediation conference, then as Conrad has stated, then there will be recourse saying that a mediation, there was a proposed date, the opponent did not pitch, or he did not want to mediate, because remember, that is still voluntary. As I understand it from the judiciary side, what they are going to compel is that a normal Rule 41A is not going to be sufficient. There must be compliance with Rule 41 first, that you attempted to hold a mediation conference. Am I correct, Yusuf, as I understood, how I understood it?
Indeed, sir. So in the build-up of your matter, and it's now time to apply for a trial date, if the RAF do not react to your Rule 41 notice, it would simply be, I would incorporate it into a trial interlocutory application at the same time. So I'll probably make my request a little earlier on and incorporate it in one of my TIC applications, and that way I can show the court that I've compelled them. If the fund do react, the other alternative is to arrange through the ADR program, I would assume, arrange the date, get in front of a mediator, get your certificate, even if they do not attend non-compliance, or compel them to apply on a particular date and attend the mediation. Those are your two possibilities. But let's hold on for that, on how to move forward. That can be debated once we had at the privilege of looking at what's proposed by the judiciary, what's implemented, and then we can work out a strategy on how to deal with a defendant who does not want to attend. I think that would be a better way to deal with it once that's envisaged. But Marianne, you're correct. The TIC courts is the way to go to compel them if you in the build-up of applying for a trial date in future. On that note, there are a few more. we've addressed the pro bono departments quite a pro bono aspect a lot. Like I said, Conrad personally dealt with that directly with the JP in this big meeting. He's also indicated that small law firms, that may be a prevention of access to justice if we cannot afford the mediators. The meeting with the LPC will continue from the Gauteng Attorneys Association side for those matters where we just can't afford it and it's a preventative measure. What the JP and judiciary is possibly looking at is that most of these matters in the utopian society would actually get settled, in which case the cost would then be follow suit and made in order of court. That's the ultimate aim from the judiciary side. I just want to highlight that. They keep reminding us that that's the ultimate goal. And if people take the mediation seriously, that is both legal practitioners for plaintiffs and defendants, that the system would actually alleviate the courts and deal with matters that need litigation. In RAF matters as well, where particular aspects, for example, generals or merits can be settled and a loss cannot, the certificate will then reduce the matter in terms of what needs to be adjudicated on by a court, and a certificate will be issued in that regard, and they're hoping that it will reduce the time. It's also envisaged that from the time of notifying the court, that they'll work much quicker. The trial dates that they will provide to you will be significantly shorter than in a year or 2 years' time. So that's what's envisaged from the court side. On that note, and if there's no further questions, I just want to bring to your attention that we do intend to run another session, if that's convenient for all our practitioners and all the different associations. Once we have the practice directive, it will be apt for us to get the mediation ADR people on this particular workshop to facilitate so members can understand how it's going to operate. We'll try and arrange that. And obviously, we'd like to have intermittent follow-up sessions to see whether or not mediation is working, whether the defendant is complying, and any issues that are going to be raised, please direct it directly to the GAA so that we as an association can bring it before the judge to deal with these particular matters. On behalf of the GAA, which incorporates PAA, sorry, is there further questions before I do the wrap-up? If not, West Rand Legal Practitioners Association, Pretoria Attorneys Association, Soweto Legal Fraternity, we'd like to thank you. And for all those attending, we look forward to seeing you soon. And good luck with planning your practice directives. Before I conclude, I'm going to give Conrad an opportunity just to address all of you and say thank you, and as well as Marianne. Thank you kindly.
Thank you, Chair. There's just, I'm just replying to a question by Anna asking, do the mediators still want to be paid 30 days post-mediation? Plaintiffs and attorneys wait longer for payment. Can mediators not be paid at a later stage? That was definitely canvassed to a full extent. There was a lot of comment based upon this, and I think one should be mindful of that there was a bunch of mediators associations as well. And of course, when this comment was brought up indicating that they become a debtor actually of the RAF, there was a lot of pushback from the Mediators Association, in part and partial, amongst others, saying that they are afraid this will impact impartiality of the mediator in the event that they become part of a payment structure based both maybe of the plaintiff or the RAF. So that comment was definitely canvassed, together with that, as Yusuf indicated, with the pro bono aspect of same. So that was canvassed. Once again, thank you for everybody. Thank you for your comments. We would maybe emphasize that there's not going to be a lot of time to comment on this practice directive. And if any, we don't know. We don't know if it's just going to be a practice directive put in place and if there is going to be even time to comment on same. But considering that everybody is running a practice and everybody is busy, we would advise to preemptively start with certain comments that you definitely would want to draw the attention of the judiciary. In the event that there's not a lot of time, then at least that is done. So, but thank you to everyone. Thank you for attending this. in the comment section, I have placed the PE municipality versus various occupiers. It's the Constitutional Court judgment that was read to us, on which the judiciary indicated that that loosely they base this decision upon. So it is there for everybody just to check in the comment section and read for your own information. Thank you, Chair.
Thank you kindly. Just one last thing before we leave, and is that the LPC distributed on the 10th of February at approximately, I think, about 5 o'clock or so, the road accident funds soliciting of inputs on the draft paper on the proposed design solution for creation of the actuarial formula to calculate loss of earnings, loss of support and general damages for the road accident fund. That road accident fund memo is dated 28 January 2025. Please go and have a look at that. It has been distributed by the LPC, directly affects everyone in the industry. I think we need to comment on that as soon as possible as well. And we'll be facing all of these things together. Thank you everyone for joining us. We hope this information session has been informative, and we'll see you all soon. All the best. Keep well. Bye-bye.